And welcome back to the afternoon session. This is Brian Ross with you for the next hour, up to the daily debrief, as we continue to have a jury watch in the case of Donald Hartung, accused of the murders of his mother and two half-brothers. The jury's been out for about 2.5 hours. We'll keep you posted. But let's turn now to what's happening here in New York in the case against Harvey Weinstein. 5 felony counts against him. And our Jesse Weber has been covering the trial throughout the week and all. Here's his latest report.
Today we heard the testimony from Dawn Dunning, one of the 3 Molyneux witnesses that the state has called to show that Harvey Weinstein has a pattern, a common scheme or plan with these women. Dunning was an aspiring actress and dancer who worked as a cocktail waitress at a club called PM back in 2004 and 2005. She had said that she had met Weinstein at the club and they developed an 8-month working relationship. According to Dunning, he invited her to the Mercer Hotel in Soho. It was a suite that he actually turned into a production office for one of his films. When she arrives, Weinstein directs her to the adjoining bedroom, where he proceeds to take up her skirt and sexually assault her. A few weeks later, Dunning claims that she was invited to another meeting at a restaurant in the Intercontinental Hotel, but when she arrives, she meets Weinstein's assistant, Bonnie. Bonnie indicates that Weinstein is actually upstairs in his room. According to Dunning, when they get up there, Harvey Weinstein opens the door, but he's only in a bathrobe. It's then he propositions Dunning into a threesome with him and his assistant. He begins to scream loudly, saying such things as, "This is how the industry works," implying that actresses such as Charlize Theron and Salma Hayek had done this in the past. She runs out, gets a cab, and goes home. During her testimony, she was highly emotional and crying at some pivotal points. But then we moved on to the cross-examination by Arthur Aidala. He hit on the fact that Dunning had done a numerous amount of media appearances and had spoken to the district attorney's office on multiple occasions, but had only discussed the Intercontinental encounter. He also hit upon the fact that unlike several of the other accusers, he didn't use any kind of physical force against Dunning. She was free to come and go into that suite, and that's exactly what she did. He concluded his cross-examination by asking Dunning about her hiring a plaintiff's attorney. Remember, the big issue here, pointed out by his defense, is that these women have come forward to extort Harvey Weinstein, or they have something to gain against him by coming forward. This is Jesse Weber reporting for Law and Crime.
Jesse Weber, thank you very much. Let's go straight away to David Ring in Los Angeles. David, you represent one of the victims in Los Angeles who's involved in the criminal case there against Harvey Weinstein. From what you heard, does it sound familiar?
It sounds very familiar. I mean, I think the prosecution's doing a great job of putting on these victims who show an absolute pattern by Weinstein of bullying his way into sexual assault and using his power and influence to take advantage of these women. He's a unique character. He was the most powerful man in Hollywood. He ends careers with an email or a phone call. And so you have this man with tremendous power. And, these witnesses, these women show you how much they were scared and influenced by his intimidation tactics.
In Jesse Weber's report, he said the information was that she was never physically assaulted. Is that necessary to make this case stick?
No, it's absolutely not necessary. I mean, that's one of these rape myths that the prosecution expert talked about, that, the rape happens by a stranger in a dark alley with physical force, and that's just not the case. And so, I think the prosecution has done a very good job of explaining to the jury that rape, the myth of rape is not true. Rape happens in a lot of different contexts.
And David, where does the case stand in Los Angeles, the criminal case against Weinstein?
Well, I mean, as we all know, the Los Angeles district attorney filed charges the opening day of the New York trial. And so, but now the LA case has to wait until the New York case is over with. And then at that point in time, they'll make arrangements to have Weinstein extradited to Los Angeles for his arraignment.
And Ashley McMahan, let me ask you, help our viewers understand why women who aren't actually part of the criminal complaint can testify about what happened to them.
Well, these women and these Molyneux witnesses are used to basically establish that this defendant is a predator and had a certain pattern of behavior that shows that he had a motive or a reason for doing this, and it bolsters the credibility of the victims or the accusers in this case. And I have to agree with David on this. One of the issues that the prosecution is really going to have to overcome, or what's going to be problematic for them, is getting these jurors to understand that it doesn't holding somebody forcefully, or forcefully assaulting them doesn't mean just physically. That Mr. Weinstein really was in such a unique position because, just as he said, you could end your career with a phone call or an email, and that these women were pressured or being assaulted in ways that many lay people, many other people could not perpetrate these crimes. So that's why they're using these other witnesses to try and show that this was something he did often, that this was a pattern, and that this was something he was used to based on his unique position in society.
Michael Carbonics, if she was free to come and go from the hotel suite, that's compelling evidence for the defense?
I don't know. I think this is I was a former sex crimes prosecutor, but this is such a unique case because it's bringing out so much attention across the country and basically across the world. And it's showing, and I think with the Molyneux witnesses, what the prosecution is showing is that it wasn't always like a back alley type of thing, that Weinstein actually, I think they refer to it sometimes as used a honeypot. He would come across as not being so predatory, but it was not one incident, it was a series of incidences that led to his violation of the rape laws. And I think it's going to be interesting. I'm doing a lot more listening in this case than talking because I think it's so unique that we're going to learn a lot on both sides.
Right, and she testified, of course, that he told her that's what everyone does. Amazing, huh? What an insight into this business.
Scary, because that's sort of something that I think will resonate to the jury, because you've always heard the Hollywood myths of the audition couch, and this is actually becoming something that's not in the movies in real life. And when these victims or alleged victims are on the stand testifying and you see their natural emotional reaction, I think it has a huge impact on jurors.
But is the casting couch a defense?
I don't think it is, and I think the prosecution has done a very good job in this case of getting out in front of that by putting on the expert early on. So now when this jury hears these alleged victims in this case testify, they have some context, and they're not going on their embedded societal prejudgment of it and saying, okay, this is what really science has shown. Now I've got to listen to this a little differently.
And David Ring in Los Angeles, do you have a sense that because of these allegations, the casting couch mentality is gone in Hollywood?
Oh, boy. I don't think the casting couch mentality ever goes away in Hollywood. I mean, that's unfortunate to say, but let's face it. I think it's going to be there. I think it's unfortunate, but I think in that industry and others, I think there are people who use their power to try to intimidate and take advantage of people of lesser power who really want to work in the industry. So it's going to keep happening, but not to the extent of Harvey Weinstein. That's unheard of, out of control, outrageous. I mean, he's the poster child for outrageous criminal casting couch conduct, and it should come to an end.
And Ashley, it's time for women to finally be able to stop this, and the courage of them to speak up and to testify, even though they think it could hurt their careers.
Yes, and you know what? I have to agree. I just don't think that these are changes that are going to happen all overnight, and we have to accept that as a society. These things happen more slowly. We are slower to change our entire culture and our thought process on this, and it depends largely on what we teach young men and young women, before they are adults or even, late age teenagers put into these situations in this industry. But I have to say, for Harvey Weinstein, I really hope his defense isn't going to be, this is just business as usual, because I don't think that's going to be the defense that's going to win it for Mr. Weinstein.
And that's why this is such an important trial, and its outcome will be so closely watched. And we'll continue here on Law and Crime to cover it every day, every minute that it happens. We have all reporters down there, a full team coverage. So let's switch gears now and get back to the case against Donald Hartung in Pensacola, Florida. The jury's been out about 2.5 hours. They had closing arguments today, and they were very powerful. Two great lawyers here, Michael Griffiths, the defense lawyer, and Bridget Jensen, somebody I know personally, who is the chief of the homicide unit in Escambia County. Here's some of her closing arguments today before the jury.
In July of 2015, Von Seal Smith, Richard Smith, and John Smith were all alive and well. They were living, they were eating, they were breathing. John and Richard had done the same type of work for over 20 years. This family of three was minding their own business, staying to themselves, and taking care of one another for years. For years. And no one tried to harm them. Until that Tuesday, July 28th, 2015, when this defendant, Donald Hartung, already had in his mind that he was ready to retire. 58 years old. He wanted to cash in on his family's fortune. He wanted the money that he knew he was never going to get. These murders were brutal, vicious, violent, and personal. You heard about the rifts in this family from the defendant's own son. This defendant was the black sheep. He was the outcast. He did not even have a key to the family's home. This defendant was excluded from his own mother's will. Does that not tell you how divided this family was? It was them, Bonnie, Richard, and John, against him. And then, when their heads were beaten and their throats were slashed, it was him against them. You've heard from the evidence. The Smith family was very unassuming. You would never know just by looking at them or what they drove or looking at their house, especially inside, that they had money. But they did. You have State's Exhibit 285 in evidence, dated March 31st, 2012, 2 months after Ms. Smith's husband died. You've got the account of John showing $213,000, the accounts of Mom showing $332,000, the accounts of Richard showing $349,000, for a total of almost $900,000.
So Bridget Jensen making clear what the motive is. Michael, is that enough to convict on a motive?
I don't think so. You know, a lot of people don't realize that motive's not even an element of the crime most of the time. It's just evidence that comes through. I think, though, this prosecutor's doing a very good job with what you have. As lawyers, we only can play the hands we're dealt. You can't make up evidence, but I think she has a very good control of her tone and her addressing and just hitting the points and moving along. She doesn't seem too emotionally involved. She seems like an advocate for the state, and I think she's doing a good job. This is the kind of thing that young prosecutors should tune into Law and Crime for, because when you see a prosecutor like this, it sort of is a real good example to follow.
Ashley McMahan, what do you think of her style here?
I think she's very smooth. She's very controlled, and she does a very good job of laying out with that visual exactly how much money we're talking about and giving the full view picture to the jury, because at the end of the day, their entire case is that he was financially motivated, he was cut out of the will, and there's nobody else who had any reason or any motive or had access to commit these crimes. So I think she's laying everything out very nicely and step by step for this jury.
All right, when we come back, some more of Bridget Jensen's closing argument as we continue to watch what the jury does in the case of Florida versus Michael Hartung. You're watching the afternoon session on the Law and Crime Trial Network.
This week on the Law and Crime Network, we're tracking the criminal prosecution of disgraced movie producer Harvey Weinstein.
Annabelle Ashura is vital to the state in order to prove the predatory sexual assault counts.
Plus, the case of a Florida man facing a possible death sentence because prosecutors say he killed his mother and brothers on the date of a rare blue moon. Was the motive financial, or was it part of the Wicca religion? The nation's biggest criminal cases are live and unfiltered right here on the Law and Crime Network. Join us for expert analysis.
We farm about 3,500 acres. There's pipelines everywhere. The contractor working on my property did not have the lines located before he began work, and it resulted on a strike on a natural gas pipeline. Fortunately, no one was hurt, but it could have been much worse. Calling 811 or visiting clickbeforeyoudig.com in the U.S. only takes minutes to do, and it can save your life.
Daniel Villegas, not guilty of...
I'm Aaron Keller. Join me for the Daily Debrief. It's your chance to catch the hottest moments of the biggest cases we cover here on the Law and Crime Network, plus the day's top legal stories coast to coast.
I didn't really think at that moment I was gonna pull that trigger.
She did it!
And his body just went boom.
An Ohio woman took the stand in her own defense today on charges she murdered her husband. Spacey faces one charge of indecent assault and battery on a person over 14.
Guilty.
I'll never see him again.
I've wanted this for quite a while.
Do you need a break, Mr. Brown?
I'll be all right, just give me a minute.
An admitted meth mommy accused of murdering her son through neglect.
Did you meet up with Cheyenne and have sex with her?
Yes.
Why do you think prosecutors put in that evidence of the mother starting a relationship with the drug buddy?
Did she have a motive to maybe hide this baby?
My dad loved Mike.
If you missed anything during our live trial coverage, we bring it to you again on the Daily Debrief. It's your chance to get caught up in your favorite cases, Monday through Friday, live from 5 to 5:30, right here on Law and Crime.
Tonight on the Daily Debrief.
Many medicines used to treat colds and flu contain acetaminophen, a pain reliever and fever reducer found in hundreds of over-the-counter and prescription medicines. But taking too much or more than one medication containing acetaminophen per day can damage your liver. So always read the label and don't take acetaminophen if you drink 3 or more alcoholic drinks every day. To learn more, visit fda.gov/OTC pain info. A message from the U.S. Department of Health and Human Services Food and Drug Administration.
Most of us like to be out in the sun. That's why sunscreen and other safety measures are key to protecting your skin from aging and cancer. The FDA recommends using a sunscreen with an SPF of 15 or higher. Also, look for broad spectrum on the label. That means both harmful ultraviolet A and B rays are blocked. Remember, SPF plus broad spectrum equal healthy fun in the sun. Visit www.fda.gov/sunscreen for more information. A message from the U.S. Food and Drug Administration.
Back now as we await a verdict in the case of Donald Hartung, on trial in Florida for the murder of his, allegedly his mother and 2 half-brothers. A grisly murder, killed with hammers on the head and throat slit. His mother's little finger cut off apparently as a way to get her to give up the combination to her safe. So Bridget Jensen, who's the prosecutor in this case, put on quite a performance today. Let's listen to some more of it.
And this defendant knew about it. Because remember, he told his coworker, Mr. Bailey, that his mom was wealthy, and when she died, he was going to get the money, quit his job, and retire. And lo and behold, ladies and gentlemen, 3 weeks later, this defendant submitted his letter of resignation. This defendant, and this defendant alone, had the motive to murder his 3 family members. That's the motive, so let's talk about the opportunity. Who knew John, Richard, and Bonnie's schedules that also had a motive to murder? That man. You've heard evidence that Bonnie, 78 years old, probably not in the best health, had fallen recently, which is why Richard had put the cameras up. She's always home, doesn't really go anywhere, sits in her recliner, orders QVC. Who knows that has a motive to murder? Donald Hartung. John Smith, you know he works at Walmart, had been there over 20 years, worked on Monday, was off Tuesday, Wednesday, worked Thursday, Friday, Saturday, and Sunday. Who knew his schedule that had a motive to murder? This defendant. Richard, you know, worked Monday through Friday, stayed late on Tuesdays because he didn't want to come home. He knew this defendant was at the family home on Tuesdays, and you heard the testimony of his coworkers. He was reluctant. He was hesitant. He did not want to go home because he knew that man was there. He worked late on Tuesdays. Who knew that also had a motive to murder? This defendant. The evidence has shown beyond a reasonable doubt that the deaths occurred on Tuesday, July 28th, 2015. You know that John's last day at work was that Monday. The Walmart employee brought the video surveillance in. He said law enforcement came to him and said, we need to know the last day that John worked, Monday the 27th. And what's interesting, if you think way back to the beginning of the trial, when law enforcement responded to the scene, they went and got Mr. Hartung, brought him back, and the officer that had been waiting there said, do you think your family's here? What can you tell us about him? And he said, well, the two cars are there, meaning Mom and Richard, so they should be there. This is on a Friday. Well, what about the other brother? He said he should be there too. This is on Friday. If John was alive, he would have been at work. This defendant said he was there because he knew he was there. That was the last place he left him after he killed him.
So motive and now Mike Krabotnik's opportunity.
But we still got to get the evidence. And that's the big thing.
Circumstantial, right, at this point?
Well, circumstantial sometimes could be much more persuasive and powerful than direct testimony.
Right.
But I just never feel comfortable when they're talking about things that don't really go to the elements of the crime. And I think as a defense attorneys, that's what you have to speak about, is they don't have to prove and we don't have to disprove motive. Motive can be very, very subjective to jurors. So I think that's a dangerous way to lead off.
And Ashley McMahan, let me ask you, is the defense is not required to, but do they have to put up sort of an alternative theory for the jury to latch onto?
All the defense needs to do is say, hey, it literally could have been anyone else. Something interesting that I noticed in the prosecutor's closing here, earlier in the trial, we saw the prosecution bring up a coworker of one of the now deceased brothers, basically to try and insinuate that they didn't like Donald or that there was some sort of animosity there. But all they were able to get out was that, they didn't have a very close relationship, and that he only came by once a week. So I don't know that it's, even though it's closing argument and you've got pretty much license to do whatever, she's painting out a picture in her closing that really wasn't established during the evidence portion of the case, which is the actual witnesses on the stand. So I don't know how effective that's going to be.
And to that point, David Ring, are you on the other side ever allowed to object to a closing argument that's just not done?
Oh boy, if you're going to object to someone's closing, you better have a really good reason why you're objecting to it, because otherwise it looks desperate. Jurors don't like it. They think you're objecting because you're worried about what the closing argument is. Personally, I rarely, if ever, object during a closing unless it's so out of bounds that you just have to preserve the record. I didn't hear anything in this closing that was even remotely objectionable.
Yeah, all right. Well, let's listen to a final clip here of Bridget Jensen in the Donald Hartung trial in Florida.
You heard that this defendant's DNA is on these zipper handles on the case. Think about this. Mr. Griffith said in his opening statement, however long ago that was, that perhaps the case was on the counter while the defendant was cooking, and he moved the case from wherever it was to someplace else, and that's how his DNA got on there. Well, maybe the outside, but the zipper handles? And not only that, but on the inside, this defendant's DNA is on Richard's checkbook. Inside. And it's a match. And the DNA expert said that there was more DNA of this defendant on that checkbook than there was Richard. You also have this defendant's phone records. He makes very few phone calls. And you have those 3 on the 30th, and you heard that this time has to be converted by 5 hours. But this defendant calls Bank of America on July 30th, 2015, 3 times. Checking his bank account. Is it low? Bills are due. July 30th. And don't forget, Richard's wallet was never located, and David Flatt said he always had cash. He always had cash. He said hundreds of dollars in his wallet. The wallet's missing. David Flatt said Richard kept his wallet in his back pocket. And don't forget, obviously Richard has been moved. This pooling of blood right here, this area on his back, shows that he was on his back. He had to be moved to this position, and this is the position where he's found. And the back of the belt is lifted up. And then you know from the DNA witness that this defendant's DNA is on the inside of the belt. And that number is greater than 1.1 billion. Not only that, but you have this defendant's bank records. And on Thursday, July 30th, 2015, this defendant deposited $100 in cash at an ATM at Bank of America. He then deposited $900 in cash at an ATM on August 3rd. You've heard the testimony of the Deerfield Drive neighborhood. One way in, one way out. Klondike Road is the intersecting street, same street that this defendant lives on, just a few miles away. You saw the front of the house, again, unassuming. Back gate has a lock on it that is unlocked. Who knows about the gate? Who knows about the lock? This defendant. He told Marlon Purifoy that he unlocked it to try and throw the investigators off. We've got a picture of the back door. Back door is closed before anyone went in, meaning crime scene, and that becomes important because of the time of death and what the experts testified to, the area temperature, the room temperature. This door is shut. Back door is always used.
Bridget Jensen, the prosecutor in the case against Donald Hartung. Let me ask you, Ashley, do you think she's making some good points here? And how do you sort of like grade her use of the documents and the pictures? Is that telling a cogent story to the jury?
Here's the part of her closing where I heard some of the most compelling evidence from the prosecution in this case. I mean, one of the brothers, Richard, had hundreds of dollars in his wallet at all times, and everybody knew it. His wallet was missing, and within days, of the murders, Donald Hartung is making cash deposits at ATMs. I mean, there you go. I absolutely love that part. I think she's doing a great job with this.
And David Ring, how do you rate it?
Well, look, I think the things that jump out at me that sell me on this man is guilty is he knows he's cut out of the will. And he knows there's 900,000 reasons why he wants to be the person who inherits it. Mm-hmm. This man is motivated by money, and this prosecutor's doing a phenomenal job of calmly walking through the evidence and laying it out, not just talking about it, but showing it to the jury and laying out a very rational timeline and motivation for this man killing his relatives.
Mike Krabonics, the jury's been out almost 3 hours now. They're starting to go through some of this evidence.
I think probably by now they're going through one piece at a time and probably going through the indictment one count at a time. And a lot of it, like you said, I think is just getting organized and, seeing who's going to take the lead and things of that nature. But I think now they're probably getting into it.
And what's the key evidence you think here? The money?
Well,
the wallet's missing. He's depositing hundreds of dollars. Where did he get that?
I'm still not sold on it. I mean, I think this prosecutor's doing a great job with the evidence she has to work with and putting that together as much as she can. The problem is, though, almost all of these activities they have to show, and I haven't heard, were out of the ordinary. Everybody uses an ATM. People have cash, not as much as they used to, but it's not like he was depositing thousands upon thousands. There's reasonable explanations. And when there's reasonable explanations for the actions of the defendant, Me being a defense attorney, I believe that's reasonable doubt.
Right. I watched her earlier last year when she prosecuted Ashley McMahan. There was no physical evidence that she had killed her friend, but they had plenty of circumstantial evidence. They had phone records. And in that case, Bridget Jensen did a really exemplary job, I think, and they got a verdict in 4 or 5 hours.
We'll see.
We'll see, exactly. So we're going to continue to watch this, and when we come back, let's take a look at the defense lawyer, Michael Griffith, who was so effective in the cross-examination. Let's see how he did in his closing statements. When we return, you're watching the afternoon session here on the Law and Crime Trial Network.
What would happen if I had to pick up the phone, call 911 for one of my family members or one of my neighbors? What would I do if no one was on the other end to respond? What if there was no 911? So you can be a part of the solution.
Anybody can be a firefighter. Male, female, younger, older.
We have school teachers. We have leaders in business.
Is me, you, anyone that wants to be. There is no typical firefighter.
Everybody can make something, because I think everyone has a spark of creativity, and the reason that I have to keep making is because I don't think my life would be as fulfilling without it. If you make things yourself, that means you're not cowering in fear. You're out there taking chances. That, I think, is my way of saying I love you to the world. All right, now I want to hear why you make.
Share your own Why I Make story today. Visit whyimake.org.
Give you a hand.
Interstate moving is much more complicated than just moving within your city or town.
Anyone can fall victim to moving fraud.
Do not sign a contract without knowing who you're dealing with.
Do the research on the company that's physically doing your moving.
Do as much diligence as you can and document as well as you can.
Do Better Business Bureau searches. I would Google the company online.
And the best place to find information is through the U.S. Department of Transportation.
Learn how to protect your belongings. Visit protectyourmove.gov.
All across the country, people are coming together to speed up what we can learn about health. The All of Us Research Program is calling on 1 million people to join us as we try to change the future of health. For your family, for future generations, for all of us. Visit joinallofus.org and find out how you can become 1 in a million.
Yes. Oh, hi. I suppose you're wondering what an A-list celebrity like me is doing in a place like this. You must know, I'm saving the world. Oh, hi, Beth. Yep, saving the world again. Did you know that 40% of all the food produced in the United States is thrown away? That means everything that went into that food, the pesticides, the water, the land, was all for nothing. Just look at this perfectly good food thrown in the trash. The pizza with extra Cheerios, these goldfish and Band-Aid tacos. And just look at this perfect trash burger. This pasta dog looks delicious.
You don't have to dumpster dive like Ed Begley Jr. to save the planet. Fight food waste by shopping smart and using what you buy before it gets trashed.
That's way better. Ooh, arugula.
Do your part and find out other world-saving tips at betterthaned.org.
Back now as we continue to watch what's happening in the Escambia County Courthouse in Pensacola, Florida, where the jury's been out now about 3 hours in the case of Florida versus Donald Hartung, accused of killing his mother and two half-brothers. According to the prosecution's closing arguments today, it was all about money. But also we had today Michael Griffith, a lawyer who has represented Hartung, who made his case. Let's take a look at some of what he said.
Well, here we are at closing arguments. This case, the prosecution of Donald Hartung, has been, for you, a 3-week journey. Hopefully not too unpleasant, hopefully fairly informative. For Donald, it's been a 5-year nightmare. Not only has he had his family, his mother, his brother John, and his brother Richard, or RT as he's known, taken from him in the most vicious and vile manner with unbelievable brutality, but he has never, ever been able to fully grieve for his family. Because within an hour of investigator Enfinger showing up on the scene after the bodies were discovered, he was accused of being a murderer and has been haunted by that accusation for the last 5 years. Ms. Jensen has done a formidable job in the first part of her closing statement, as she did in her opening statement. Or I guess it's closing argument, really, because we're arguing to you what our belief of the facts are. I am going to do my best to stick to the facts that you've heard from the witness stand and the pieces of evidence that have been introduced. There's a lot of fact that Ms. Jensen gave you. There's a lot of fantasy. There's a lot of fantasy in what she said. She wants you to assume things that are not in evidence. And when the judge gives you his closing argument, he's going to tell you it's to the evidence that you heard in this case and to that evidence alone that you are to base your decision. Your verdict is from the evidence, not a flight of fantasy that you may hear from this podium right here. For instance, Ms. Jensen said, well, Donald turned off the TVs. There's no evidence to that. Every one of you has been taking notes through the entire case. And it appeared to me you've been taking copious notes. Review your notes and see if anywhere any witness or anyone else told you that there was any evidence that Donald Hartung turned off the TV. Were his fingerprints on the television? Were his fingerprints on the clicker for the TV? There's no evidence of that. So what I'm asking you to do when you go back to the jury room to begin your deliberations, I want you to separate the fact from fiction. This is not a crime novel, a mystery novel. This is real life. You're a real jury, and you have taken an oath to render a verdict based on the evidence you hear in this courtroom.
So defense lawyer Michael Griffith beginning by taking on the prosecutor, Bridget Jensen. What do you think, Matt Krabonix?
I'm not a big fan of that. I think, as lawyers, it's the state versus the defense. And to personally refer to someone to say they're not credible, I think you run a risk. There may be jurors who find she's very credible, and you may alienate yourself from that jury. I think what he did do, though, I enjoyed his theme, and I thought it's effective about fact from fiction. If you say the prosecution failed to back up that representation, I think that's a good way to chip away at their case.
Right, and actually he talks about don't pay attention to fantasy you heard from this podium.
Yes, Michael Griffith has been very personable throughout this trial, but I do agree that, anytime you basically call the other side a liar and you do it by name, jurors don't really like that. But, calling them the government or the state would have you believe X, Y, and Z. And I noticed you taking copious notes, I believe is what he said, I think is a good tactic for kind of rewarding the jurors for paying attention and saying, hey, now we're going to break down all the evidence that you saw and I'm going to stick to my theme. So I did like that part of it.
And David Ring, he's been practicing since 1974 in Pensacola. He must know what he's doing.
Oh, sure. I mean, he's a competent, experienced defense lawyer. I mean, I take issue with him with this TV thing saying, hey, boy, you know, she made it up that Hartung turned off the TV. I mean, really? I mean, if you're making that the centerpiece of your argument, it's such a non-fact, non-issue. No one cares about that. But, you know, he's trying to get these jurors to really say, hey, unless we heard it from the witness stand, we're not going to make any assumptions about anything in this case. You're allowed to make reasonable inferences from the evidence, which is what the prosecutor is arguing. That's what closing argument's all about.
Right. Let's watch some more of his closing arguments from this morning in Pensacola.
He latched on to Donald, and from there on, it was Katie bar the door. Every bit of evidence was going to involve Donald. We weren't going to follow up any of this other DNA. That was it. Donald was the subject, and we're going to make sure the evidence fits who we think did the crime. I would not harm my family for nothing in this world. That was repeated by him. He never asked for a lawyer during the first interview that lasted over 3 hours, and repeatedly told him, after investigator Enfinger repeatedly said, I know you killed your family. You killed your family. He was brutal to Mr. Hartung, trying to break him down after learning that his family had been murdered. And Mr. Hartung acquiesced to every request that investigator Enfinger had for him. He said yes. Never said no, never said I want a lawyer, never said anything. He helped the investigation as best he could. Then, after being taken home, he was awakened at approximately 1 a.m., just a few hours after that first interview. And a second interview was held. And that was with Sergeant Coxwell of the Sheriff's Department. And in that interview, he again said, I did not kill my family. He's told the investigators, I love my family, I would not hurt them. He proudly talked about Richard.
So David Ring, is that persuasive?
Oh boy, I mean, that cuts both ways for me, you know? I mean, on one hand, it's persuasive, the fact that if you're looking at Hartung and you're inclined to think he's innocent, then it's persuasive. Hey, he didn't call for a lawyer. He seemed to, you know, despite being hammered over so many times, you did this. He says, I didn't do it. You know, he doesn't break down. On the other hand, if you're inclined to think he's guilty, okay, anyone can sit there and deny that they didn't commit the murder. I mean, how tough is that? I didn't do it.
Ashley McMahan, do you think there's any sympathy being generated here for Donald Hartung?
Well, I mean, while I don't advocate for anyone who's been potentially accused of anything to start talking to the police without getting a lawyer first, it is certainly something that we are seeing that your defense attorney can use in their closing argument as a plus on your side for having cooperated and said so many damaging things in your initial police interviews that definitely came into trial in spite of denying that you committed the crime at all. So it does cut both ways.
Sort of the theory, Michael, that if you're an innocent man, you don't need a lawyer.
Well, that's what every client says when you get a not guilty verdict at the end of the trial and they don't think we've done anything for them. But it's interesting because in New Jersey, at least, defense cannot use confessions to introduce on behalf of their clients because the rules of evidence say they're self-serving. I believe the prosecution introduced this evidence to show his demeanor, for lack of a better term, which I think is a risky thing to do because it always comes down to risk-reward when you're introducing evidence. And I think by introducing it, they gave the defense an ability to have their client speak to this jury through that tape without being cross-examined.
Absolutely.
Big plus.
Well, I guess so. All right, some more of Michael Griffith's coming up as we continue here on the afternoon session on the Law and Crime Trial Network.
I'm Dan Abrams, and this is the Law and Crime Network. Hey everybody, I'm Jesse Weber, and this is Legal News You Can Use. So you ever watch a soap opera and the issue comes up about the wealthy patriarch not leaving anything in his will to his wife or kids? Well, if you haven't, then clearly you aren't watching quality television like me, but it gets you thinking. Can you disinherit your spouse or children? Let's start with the kids. In almost all states, you don't have to leave your adult children anything. It's pretty surprising, right? However, this doesn't mean all kids. You usually can't disinherit minor children, and in Louisiana, you not only can't disinherit those under 23, but also those who don't have the mental capacity to take care of themselves. Oh, and of course, this also doesn't include if a court orders you to leave them something, like, say, in a divorce. But if you really want to disinherit your adult children, and remember, don't make that decision lightly, you'll have to make sure you have a will or some kind of estate plan, because if you don't, and you don't have a surviving spouse, guess what? Generally, the law says your stuff is going to your kids. Now, what about your wife or husband? Well, this is where it gets tricky. Most states say you can't intentionally disinherit your spouse unless he or she agrees, usually in a pre- or post-nuptial agreement. Okay, then you're asking, what is your other half entitled to? Depends on the state. Some look at how long you're married, if you had children together, and if there are any assets that need to be probated. Look, this can get complicated and messy, so as with everything, consult with an attorney first. For more legal news you can use, go to lawandcrime.com.
Trisha's having a sleepover tonight. Can I go?
I wonder about Lucy's friends. What should I say? I know you're only 10, but one of these days a friend will offer you a drink. And alcohol at your age can lead to so many things. None of them good.
So can I go to the sleepover?
Lucy, I want you to promise me
I
something.
finished my homework.
Bigger promise. If there's any drinking, I want you to say, "No thanks, not my thing."
Mom.
I promise you. Your real friends won't care. Deal?
Sure.
Really?
I promise, Mom.
They really do hear you.
Did you pack your toothbrush?
For tips on how to start the talk, visit underagedrinking.samhsa.gov. A public service message from the Substance Abuse and Mental Health Services Administration.
And we're back now, continuing to watch the courthouse in Pensacola, Florida, the Escambia County Courthouse, where a jury is out in the case of Florida versus Donald Hartung, accused of killing his mother and 2 half-brothers in a grisly murder. His lawyer, Michael Griffith, made quite a performance today in the closing arguments, and here's some more of what he had to say to the jury.
When you're back there in that jury room, if you believe my client is probably guilty, maybe guilty, possibly guilty, that means you come back with a verdict of not guilty. You are not here as investigators to determine who committed the crime. You're not vigilantes to avenge the murders of these people, but you're here to rationally evaluate the evidence, talk about the evidence, talk about the lack of evidence, talk about a conflict in the evidence, to come up with your decision. Now, you're going to have jury instructions read to you by the judge, and part of one of the jury instructions is called reasonable doubt, burden of proof. If after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. Now, the doubt is not to be speculative, imaginary, or forced. That cannot have you bring back a not guilty verdict. But if it is one that is not abiding or one that is not stable but wavers and vacillates, then it is your duty to return a verdict of not guilty. There's another called weighing the evidence. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? That goes to Mr. Purifoy. Now, Mr. Myers asked my witnesses if they'd been paid and how much. They were all paid to come here. They don't work for free. They're paid through the Judicial Administration Commission. Florida, the state of Florida is paying those witnesses just like they pay the prosecutors, just like they pay Ms. Wilkerson, Investigator Enfinger. Everybody gets paid for their work, and these people are no different. They fly down here and they testified. The court's further going to tell you, you must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. That applies to Mr. Purifoy 100%.
Well, there's Michael Griffith, who's Donald Hartung's lawyer. Michael Krabonics, he's giving the jury the instructions that the judge is going to give the jury. Why be redundant?
I think it's very effective, and it's pretty old school, and I've learned that from older lawyers when I was an up-and-coming prosecutor. The jury's going to hear him talk about reasonable doubt. He used it in his cross-examination. He's using it again in his summation. Then they're going to hear the judge read exactly what he's talking about. And I think that sort of gives an implied endorsement to say, you know what, the defense attorney was right. Even the judge is saying it.
All right. Ashley, what did you make of that closing, those final thoughts there?
Yes, you got repetition here, and they're going to hear the judge say the same thing, which gives validity to everything that Michael is saying in his closing. It makes him sound far more credible to the jurors who may not, be official jurors every single week, and this may not be their job. This may be their only chance at it. So he's going to come off as more credible. I think it's a great tactic.
And David, reasonable doubt is the standard, right?
Reasonable doubt's the standard. The X card, the X factor here is this informant, this jailhouse informant. And so you heard this seasoned defense attorney do a good job of starting to introduce, can you really trust this jailhouse informant? Was he paid? What's he getting out of this? And he's starting to, try to sow the seeds of doubt in the jury's mind about the informant and a lot of other things.
So we don't know what's happening. The jury's been out now a little more than 3 hours. We're getting a feed in from the courtroom. The judge is back in there, not quite sure what's happening yet. No word on the outcome. But at this point, it's like after almost the end of the day. It's an hour earlier there, so it's really coming up on 4 o'clock in Pensacola. This would be a very quick verdict if it came now. Would you say, Michael?
I think for this kind of charge, absolutely, it's a quick verdict if it's coming out now. And not good.
Not good if that's the case, right? And Ashley, as you watch all that, what was left out, do you think, in what we've seen from the defense closing argument?
Well, I didn't see a lot of, a major enthusiasm, which sometimes, attorneys, especially defense attorneys, when things aren't going well or the evidence doesn't look great, they tend to hammer on the table and yell during closing argument. But Michael didn't need to do that. He was very calm, very controlled, obviously very experienced, knows his stuff.
David Ring, he's low key, but that's has an impact.
Yeah, look, every lawyer will tell you this. You have to be yourself. He doesn't strike me as the guy pounding the table and ranting and raving in a courtroom. He's calm, and that's his style. The one thing that I did not see in his closing yet, and maybe he did it, but I didn't see it, is his use of the evidence. The prosecutor did a great job putting the evidence up there, mixing it up with her argument. I just saw him standing there talking. Maybe that's enough. Maybe it isn't.
And his argument, this was all mostly fantasy, the very few facts, because there really is no evidence that puts his client at the scene.
I think there's a lot of circumstantial evidence that puts him at the scene, but no, there's no eyewitness who says, I saw Donald Hartung there with a hammer in hand.
Right, and Michael, finally, the circumstantial evidence still has a bearing.
Well, it does, and I think the prosecution is taking that circumstantial evidence and using motive and opportunity to shore it up.
Yeah, all right. Well,
But I'd like to see what the appellate court thinks of that if he gets convicted, though.
absolutely fascinating.
Yes.
The jury is out. I want to thank you, Michael Krabanix, Ashley McMahan in Atlanta, and David Ring in Los Angeles. A fascinating last 2 hours. Stand by now for the coverage of this trial, and Aaron Keller takes over the seat with a daily debrief. This is Brian Ross. Thanks so much for being here the last 2 hours. It's been a blast. Enjoyed talking to all of you. Have a good afternoon.
Hey everyone, I'm Jesse Weber, and this is Legal News You Can Use. Today's topic, what happens if you don't pay your credit card bill? Let me just say, don't put yourself in this position, all right? It's not one you want to be in. First, the credit card company will start to contact you after your first missed payment, usually when you're 30 days late. Now you may think, oh, I'll just ignore them. Well, after 60 days without paying, your interest rate could skyrocket. I'm talking doubling or even almost tripling. You also probably have to pay a late fee and your credit score could go down. So are we having fun now? Well, it gets worse. After 90 days of non-payment, the credit card company could terminate your account and then sell your debt to a collection agency. In some states, you could then be sued, which could result in a garnishing of your wages and or a lien placed on your bank accounts or property. I told you, not good. Here's a tip. If you're gonna have trouble paying, get in front of this. Don't ignore the credit card company or debt collection agency. Communicate with them and be honest. You may be able to work out alternative payment plans, and in some cases, it may be wise to retain an attorney. Go to lawandcrime.com for more legal news you can use.
If you're talking, they will hear you.
We all want our kids to grow up safe and healthy, so we show them how. And we tell them with honest conversations that let them know what we expect. Not just one time, but every chance we get. That's especially important when it comes to alcohol and other drugs. Kids not only need to know the dangers and how to avoid them, they need to hear it often from you. And when it comes to pain medications, opioids, they need to know that they should never be taken without a prescription and never shared with friends or family. It's dangerous and illegal. So talk with your kids and guide them through the challenges of growing up safe and healthy. Because when you talk, they hear you. For more information about talking with your kids about underage use of alcohol and other drugs, visit underagedrinking.samhsa.gov.
So talk, they hear you. You can do it if you try.
Can I go to the sleepover?
Lucy, I want you to promise me something. If there's any drinking, I want you to say, no thanks, not my thing.
Mom.
I promise you, your real friends won't care. Deal?
I promise, Mom.
They really do hear you.
Did you pack your toothbrush?
For tips on how to start the talk, visit underagedrinking.samhsa.gov. A public service message from the Substance Abuse and Mental Health Services Administration.
A brain aneurysm can strike you when you least expect it, plunging your entire world into darkness. But if you know the warning signs, you're much more likely to survive. If you suddenly experience the worst headache of your life or sharp, sudden pain behind your eyes, do not ignore it. Please seek immediate emergency attention. It's time to shed some light on brain aneurysms. You gotta know the information.
The Lisa Colagrassi Foundation, lisafoundation.org.